federal government seeks to imprison Jesse Bullock for possessing a firearm as a convicted felon. Mr. Bullock claims that this is a violation of his Second Amendment rights. He observes that he finished serving his sentence long ago, and the available evidence indicates that the firearm the government complains of was kept in the sanctity of his home. Yet, 922G1's ban on gun possession is a lifetime one. The question presented appears simple. Has the government demonstrated that, as to Mr. Bullock, the federal felon in possession ban is consistent with America's historical tradition on firearm regulation? The government says the answer is also simple. Yes. It points to more than 120 U.S. District Court decisions which recently determined that the government had met its burden, at least in those cases. This court is not so sure. The government's citation to the mere volume of cases is not enough. There also is doubt about the process those cases used to determine the history of the felon in possession ban. In none of those cases did government submit an expert report from a historian justifying felon disarmament. In none of those cases did the court possess an amicus brief from a historian. And in none of those cases did the court itself appoint an independent expert to help sift through the historical record. It is unsurprising that the government relies on jurisprudence filled with such methodological flaws. The same errors define the Supreme Court's own Second Amendment jurisprudence. In Heller, Justice Scalia's opinion for the court conducted a de novo review of history using the parties' briefs and amicus briefs from academics. This was surprising in light of Justice Scalia's long-held belief that, quote, sign-on, multiple professor amicus briefs in a case are a political rather than an academic exercise, motivated by partisanship and hopes for preferment. It was further surprising, given Justice Scalia's disapproval of the court's, quote, picking and choosing those studies that support its position, end quote, while, quote, never explaining why those particular studies are methodologically sound. Justice Scalia knew firsthand the risk of cherry-picking briefs to support one's ideological priors. Yet it appears that the court continues to engage in law office history. That is, history selected to fit the needs of people looking for ammunition in their cases, in constitutional interpretation. The judge starts to slay the government right here. Nonetheless, the standard announced by the Supreme Court in Bruin is the law of the land. It must be enforced. Under that standard, the government has failed to meet its burden. The federal felon in possession ban was enacted in 1938, not 1791 or 1868, the years the Second and 14th Amendment were ratified. The government's brief in this case does not identify a, quote, well-established and representative historical analog, end quote, from either era supporting the categorical disarmament of tens of millions of Americans who seek to keep firearms in their home for self-defense. American history might support state-level felon disarmament laws that at least would align with principles of federalism. It might support disarmament of persons adjudicated to be dangerous, as Justice Barrett found when she sat on the Seventh Circuit. She dissented in that case. And it likely does support disarmament of persons convicted of death-eligible offenses. The power to take someone's life necessarily includes the lesser power to disarm them. The government's arguments for permanently disarming Mr. Bullock, however, rest upon the mirage of dicta, buttressed by a cloud of law review articles that do not support disarming him. In Bruin, the state of New York presented 700 years of history to try to defend its nearly 1900s era gun licensing law, and that was not enough. Bruin requires no less skepticism.